A New York State landlord won a big victory in court against a law that says that they must accept Section 8 tenants. This could have big implications for landlords in the state. I'm Tony, and this is Real Estate Investing and Landlord News. All right, so I have an interesting article for you today, and it's going over this court decision against the New York State law that requires landlords to accept Section 8 tenants. Okay, I've talked about these sort of laws before, and I've talked about how, in my opinion, landlords should be the ones who make the determination of whether they participate in the Section 8 program because it's supposed to be a voluntary program. It's not supposed to be one of those things where landlords are forced to participate in it. And there's a multitude of reasons. And the argument that this landlord used in this court case was a very good reason. Basically, Section 8 requires properties to be inspected, right? So by telling a landlord that, hey, you have to participate in the Section 8 program, you're telling the landlord that you have to submit your property to searches, government searches, and without your permission. Okay, so basically, it's a Fourth Amendment issue, and the state judge agreed. Okay, and so they won this case, and this could mean that any law within the state of New York, at least, that says that landlords have to accept Section 8 tenants, and supposedly against income discrimination, right? Those laws could all be thrown out. Okay, I mean that's how powerful this case here is, right? And I'm hoping that that is what it comes to be. Okay, so before I get into the article, go ahead, hit the like and subscribe button, maybe leave a comment down below, and let me know what you think. Obviously, there's a lot of different landlords who watch my channel. There are landlords who've commented before from New York State. So what do you think of this kind of court decision? I'm going to go over the details of the court decision for those who don't know, just in case. But, what do you think of a court decision saying that, hey, it is an illegal search if the government forces you to accept the Section 8 tenant and then have your property inspected? Do you agree with that? Do you think the judge was right in that call, or do you think it's wrong? Okay, I'm just curious. What do you think? But anyway, let's get into the article. I want to go over these details. This article is coming from 14850.com, and it says, State Supreme Court sides with Ithaca Renting. Section 8 inspection requirement makes New York State rule unconstitutional. And that's what you want to hear. You want to hear that these laws that they're passing are unconstitutional. Okay? That is the most powerful argument against most of these laws. Okay, so anyway, let's get into it. The Office of the New York State Attorney General filed suit last fall against the Ithaca Renting Company, a local landlord with numerous commercial properties and apartment buildings, saying its refusal to rent apartments to would-be tenants using Section 8 housing vouchers for payment was in violation of state housing law that prohibits landlords from discriminating against tenants on the basis of income discrimination or the source of funds to pay their rent. Now, a New York State Supreme Court judge has ruled for Ithaca Renting, agreeing with the local business's position that Section 8 program's inspection requirement was a violation of the Constitution's protection against searches. Now, this is a different argument than I've heard before, right? But it's a good argument, okay? And the Supreme Court in the state of New York, they agreed with it. And like I said before, this could make it so that landlords no longer have to accept Section 8 tenants. And that would be a very, very good thing. In his ruling on June 27th, Mark G. Masler says the Attorney General's argument is fundamentally flawed for the simple reason that, as set forth above, a landlord cannot accept the Section 8 housing voucher as payment for rent without agreeing to participate in Section 8, which in turn requires that the landlord authorize warrantless searches. So yeah, the landlord would be forced into authorizing warrantless searches by the government because the law forces them to participate in a program that they don't want to participate in. See, this is the problem. This is the problem, right? And so they are violating the Constitution. There's so many of these different laws that I've talked about before, they're violating sections of the Constitution. And unfortunately, it gets to a certain level of court and they don't think, oh, this isn't a problem. This isn't a problem. Well, yeah, it is a problem. It's a huge problem. Our country is based upon, the Constitution, the amendments to the Constitution, and we need to follow that. We need to follow that. Otherwise, what good is the document? What good is it? You know? Judge Masler's ruling points out that the housing assistance payment contract entered into by landlords participating in Section 8 requires a participating landlord to consent to inspection of the contract unit and premises at such time as the PHA determines necessary, and to provide the PHA, the Department of Housing and Urban Development, and the Comptroller General of the United States full and free access to the contract unit and the premises and to all accounts and other records of the owner that are relevant to the HAP contract, which includes access to any computers, equipment, or facilities containing such records. Ithaca Renting has contended that the source of income anti discrimination statute violates a property's Fourth Amendment rights by giving the owner no choice but to consent to these inspections by entering into a HAP contract. And I agree, okay? Now, the question is, right, like I know that this is in New York State, right? And I know that, this was successfully argued in New York State, but the truth of the matter is this could apply in any state. This is the argument that landlords in places like California or states like New Jersey, other East Coast states that have these sort of laws, this is the argument that these landlords need to be using in their court cases against them. Okay. And hopefully the judges in those other states, those other places, they will come to the same conclusion. In fact, it probably would be better to fight this sort of thing in federal court with the same argument, because then the federal court would be able to nullify all these laws throughout the entire country. And that's what I want to see. I don't want to see these laws anywhere. I've said many times, the landlord should be the one who makes the determination of who is going to live in their property, not the government. The government shouldn't be involved in our business and saying, well, you have to take these tenants that you don't want. No, that's ridiculous. That is ridiculous. I do not agree with that. I'll never agree with that. As written, the requirement that landlords consent to its inspections at times as the PHA determines necessary could conflict with New York state law prohibiting a landlord from entering a tenant's apartment without reasonable notice, except in an emergency. And the ruling could also call into question the inspection requirement of new short term rental laws being enacted or considered in some local communities. Today's decision by Justice Masler striking down as unconstitutional the 2019 amendment to the landlord tenant law, which compelled participation by landlords statewide in the voluntary federal Section 8 program, is a victory for the rights of small business owners and the civil liberties of every citizen. Ithaca Renting's Nathan M. Lyman told 14850 today in a statement that afternoon. Ithaca Renting Company is thankful that the court studiously considered our arguments and found that they were correct. And I like reading this sort of thing. Okay, I like reading this sort of thing because you know what? I haven't heard this thing fought in this way, in this manner before, and the fact that it was successful, tells me that hey, they were on to something. They knew that hey, this is not constitutional. We need to get rid of this law. And sometimes you have to go through the courts in order to do that because the politicians, they're not listening to us. They are trying to get votes. They're going to sit there. They're going to pander to the tenants. They're going to be like, oh yeah, we're going to do this, we're going to do that, and it will be something that basically violates the law they're trying to pass. So it's ridiculous. More than 40 years ago, New York's highest court wrote in Sokolov versus Village of Freeport that it is beyond the power of the state to condition an owner's ability to engage his property in the business of residential rental upon his forced consent to forego certain rights guaranteed to him under the Constitution. Ithaca Renting told us last fall in a statement sent by Curtis Johnson of Rochester law firm Bond, Shonek, and King, PLLC. Under the Sokolov versus Village of Freeport decision from the Court of Appeals of the State of New York, the court ruled that the village could not require landlords to have properties inspected before rental, saying the village ordinance effectively requires a warrantless inspection of residential rental property. And yeah, I agree with that. Okay. And I have successfully, or I've seen other places successfully argue against rental inspection programs with that exact same argument. Okay. And it's a good argument. It's a good argument. And I'm glad that these landlords, they won their case. Hopefully this sort of thing, it spreads throughout the entire country and we see similar results, because I don't think any landlord should be forced to accept a tenant that they don't want.